Thank you for visiting my channel. Before we start, please hit the subscribe button so you'll be notified of future presentations. Our topic for today is consideration under Articles 24 to 28 of the Negotiable Instruments Law. For those who have my book, The Law on Negotiable Instruments, the following discussion is found on pages 114 to 121 of the book. Section 24. Presumption of consideration. Every negotiable instrument is deemed prima facie to have been issued for a valuable consideration, and every person whose signature appears thereon to have become a party thereto for value. The presumption here is only prima facie. Though consideration is presumed to have been given for every obligation on a negotiable instrument, the truth may be shown by any party, and if and when shown that no value or consideration in fact existed, the defense will be good as against anyone but a holder in due course. Section 25. Value what constitutes. Value is any consideration sufficient to support a simple contract. An antecedent or pre-existing debt constitutes value and is deemed such whether the instrument is payable on demand or at a future time. What is necessary to make a promise legally enforceable as a contract? The promisee must give something or promise to give something to the promisor, and the thing so given or promised as consideration must be something to which the promisor was not previously entitled. Doing or promising to do something which one was previously legally bound to do is not sufficient consideration. The thing given or promised as consideration need not, however, be tangible. It may be the surrender of a right or the forbearance to enforce a claim, but the surrender of a right known to be invalid or the forbearance to prosecute a claim known to be unfounded is insufficient consideration. In order to make a promise binding on a negotiable instrument, it is essential either that the promisee shall have parted with something, or that the promisor, the obligor on the instrument, shall have received something, but it is not essential that both shall concur. Illustrations. First illustration. A is indebted to B. C wishes to pay A's obligation to B. C issues a note to B in satisfaction of A's debt. C has bound himself by that instrument, although he has received nothing. B has given up something, namely his claim against A, and that is enough consideration. Second illustration. A is indebted to B. B wishes to make C a present, so B requests A to issue a note for the amount to C. In this case, A received something, since he has been discharged from B's claim. But C, who holds the instrument, has given nothing for the note, but can recover on it. To repeat, if either the obligor has received something or the holder has given something, there is sufficient value or consideration for a negotiable instrument. Section 25 also holds that a negotiable instrument may be given for an antecedent or pre-existing debt. If there is an antecedent debt, the antecedent debt may be paid for or may be secured by a negotiable instrument. Section 26. What constitutes holder for value? Where value has at any time been given for the instrument, the holder is deemed the holder for value in respect to all parties who become such prior to that time. In simple contracts, consideration is not presumed, so that when the creditor sues the creditor must allege and prove sufficient consideration to support the contract. Under Section 24, however, every negotiable instrument is deemed prima facie to have been issued for a valuable consideration, and every person whose signature appears thereon to have become a party thereto for value. But though consideration is presumed prima facie to have been given for every obligation on a negotiable instrument, the contrary may be shown by any party if no value or consideration in fact existed. That defense is available against any holder except against a holder in due course. A further feature of consideration in negotiable instruments is that if an instrument has once become binding, or if an obligation on an instrument has become binding because the obligor has received value or a holder has given value, lack of consideration and subsequent transfers is immaterial so far as concerns the liability of parties to the instrument at the time when value was given or received. Illustrations. First illustration. A wishes to pay B's debt to C. A issues a note to C, who receives it in payment of B's obligation to him. A has received nothing, but C has surrendered his claim against B, so the note is binding. Second illustration. A issues a note to C in payment of B's obligation. C gives the note to D as a gift. D has given nothing for the note, and A has received nothing for his promise on it. Yet the note is binding because it was binding in C's hands, and D succeeds to the rights of C. Section 27. When lien on instrument constitutes holder for value. Where the holder has a lien on the instrument arising either from contract or by implication of law, he is deemed the holder for value to the extent of his lien. If a negotiable instrument, which is subject to an equity, is pledged as security for a debt, the pledgee, if a holder in due course, is protected to the amount of his advances. Illustration. The maker is fraudulently induced by the payee to sign a negotiable note for 10,000 pesos. The payee transfers this note to secure a note of his own for 5,000 pesos. If the lender took the 10,000 peso note in good faith, he can recover 5,000 pesos on it. Suppose the lender subsequently advanced a further sum of 2,000 pesos on the faith of the 10,000 peso note. If this further advance was also made in good faith without notice of the fraud, the lender could now recover 7,000 pesos from the maker of the note. If, however, the 2,000 pesos was advanced after notice of the fraud, the lender could recover only 5,000 pesos which was first advanced, as he was then acting in good faith, but could not recover the later advance. Section 28. Effect of want of consideration. Absence or failure of consideration is a matter of defense as against any person not a holder in due course, and partial failure of consideration is a defense pro tanto, whether the failure is an ascertained and liquidated amount or otherwise. Absence of consideration is where no consideration was intended to pass. Failure of consideration implies that consideration was intended but failed to pass. Absence or failure of consideration is a matter of defense as against any person not a holder in due course, and partial failure of consideration is a defense pro tanto, whether the failure is an ascertained and liquidated amount or otherwise. Pro tanto is a Latin phrase which means only to that extent, and is often used to denote partial fulfillment of an actual or potential obligation, often in the form of partial payment, toward a claim asserted in a lawsuit. Suppose a note is given in return for a promise to deliver goods later. There is no lack of consideration, strictly speaking, for this note, because there was a promise to deliver the goods, and a promise is sufficient consideration for the note. But if the goods are not delivered when the time comes, there is failure of consideration, because the thing expected was not given, the promise has not been kept. And thus, where there is failure of consideration, the person who was to give the consideration cannot recover because he has failed to give it, and any holder who took the note, knowing that the consideration had failed, will similarly be unable to recover. However, the defense of want of consideration is ineffective against the holder in due course, and a drawee who accepts the bill cannot allege want of consideration against the drawer. Who has the burden of proving that a negotiable instrument was issued without sufficient consideration? The drawer of a check, not the payee, has the burden of proof to show that the instrument was issued without sufficient consideration. Since a negotiable instrument is presumed to have been issued for a valuable consideration, The mere presentation of a dishonored instrument in evidence entitles the holder to recover from the drawer even if the payee did not establish the accountability of the drawer. He who posits that there was no consideration is obliged to present convincing evidence to overthrow the presumption that every negotiable instrument is acquired by every party for value. Since consideration is presumed, the maker is liable to pay under a negotiable promissory note. Since a check which was dishonored for lack of funds is presumed to have been issued for valuable consideration, the drawer should be ordered to pay its value if he failed to rebut the presumption. The foregoing discussion has been based on the book, The Law on Negotiable Instruments, by yours truly. If you find this presentation helpful, hit the subscribe button so you'll be notified of future presentations. Thank you.